Good morning, everyone. For those of you who may not know me, my name is Renee Adorjan. I am the Michigan Department of Health and Human Services Director here in Washtenaw County for the state of Michigan. And we have invited you all here today to join us for this meeting. What we had talked about in our JET meeting, which is the Judicial Engagement Team meeting, was that we needed to get you all together so you could have some snacks, have a chance to talk outside of the courtroom, because I think a lot of you probably, the only time you see each other is when you're actually in the courtroom. And Adelia Clark, who's our program manager, and I attend the JET meeting, and we just know that the judge and the referees are just such warm, fuzzy individuals. And so we wanted you all to have a chance to experience that as well. This is counting as training hours for any of my DHHS staff. So if you're able to stay for the entire morning, that would be 3 hours of training. If you're able to stay for us for our lunch presentation, that'll be 4 hours of training. And in the afternoon, folks will get their training hours as well. Just a few housekeeping items. There are snacks in the back. Please feel free to, if you need a cup of coffee or some sugar a little bit later on, feel free to help yourself to that. There are also restrooms out the doors, down the hall to the left, and feel free to, if you need to. We will have a break about halfway through the morning, but if you need to get up and use the restroom, please feel free to do that. We do ask that you continue to sit in the groups that you've been assigned to. There's a reason behind that. We also, on your table, have some 3x5 cards. These are note cards, and the reason that you have them is we have an absolutely jam-packed agenda, and we're not going to have much any time for everyone to ask questions, but we figured that you're probably going to have some questions. So please use those note cards to jot down the questions that you might have, and if you specifically are looking for a response back to you, make sure you put your name and your contact information, like your email address on that. If it's just kind of a general question, we are going to collect all the questions, review them and get answers, and then be able to send the responses out to everyone. So because we figure, especially if a question comes up time and time again, if you have a question, probably other people have a similar question, and so we want to make sure to try to address any of those questions and concerns. I hope I said that what we were looking at is this being the first of many meetings where we have a chance to come together like this, which is another reason why I expect there'll be a lot of questions. We're also looking for ideas for future discussions, future things for us to get together and talk about. So please utilize those note cards for that purpose. We are also going to ask you to complete a survey at the end of the session, because again, we would like to get your feedback and use it for planning purposes for the future. So those are kind of the housekeeping items to get us started this morning. And I would just like to turn this over to Judge Connors for his comments. Thank you.
Well, welcome everybody. Oh, come on, there we go. Lord almighty, winter's still here, we gotta chase it away, don't we? I really want to thank Renee and for this opportunity. We decided to do this together with the Peacemaking Court and with DHHS. And it is an ambitious agenda, and we're really grateful for the speakers today and the assistance of Belinda Doolin to help us on the exercise. We thought this was appropriate because this is a mixed group, but all of us have a piece of that shared collective responsibility that we have undertaken and committed ourselves to our youth and our families and our communities. And it's hard. We were with Dr. Henry. Dr. Henry's going to help us set up a resiliency court in our peacemaking court, and he was talking and sharing that he met with many of you last week and just about that secondary burnout that we have and can have. I was with Belinda Doolin. Belinda Doolin teaches this incredible class at Wayne State. She's putting her head down. I'm talking about her. But I'm talking about her because the work she's doing, in one of the groups in there, they're talking about restorative justice, wide range, and there was a CPS worker who just said, I'm burned out. I'm going to go into labor relations. I'm so burned out. So, you know, if that's happening to us, we have to acknowledge it, we have to acknowledge why. But think about if that's where we're at, what are we bringing to these kids that are already hurt? So we start from within, we start with each other, we focus less in peacemaking on competition is not a value, cooperation and collaboration is. It's not about winning or losing. It's about a shared wisdom and trying to figure out what we're going to do. So it's an ambitious agenda. It is the beginning of conversations. It is the way to talk about what we're going to do together in Washtenaw County. And we're focusing just on removals. But is that not really where we should start? We know from the adverse childhood experiences, we know this even in domestic relations, when parents are splitting up and suddenly we're in visitation or one parent has primary custody, even there, that separation from a parent is one of the adverse childhood experiences. That's one of the things that goes on the chart that already traumatizes a kid and gives them a frame of reference that makes them difficult to feel connected in the world. So when we do a removal because we know a child is traumatized, we have already added to the trauma in a significant way. We have to be very careful that if that's what we're doing, we're only doing it when it's truly the emergency, because we've already dug a bigger hole for that child that we have to bring back. So today, that's why we have the two sessions, we'll really look at this from a number of perspectives. One of the things we're very thankful for in Washtenaw County is that we have actively involved with us the University of Michigan Law School Child Advocacy Clinic. I say this for a number of reasons. First, the degree of professionalism and civility that they bring to the table, which is so important to set the tone. But secondly, even more importantly, because they are seeing what is happening across the country, they have time to really be looking at what can and should be done and where it's being done. They're always on top of the law so that we know we're following the law. We have that, and that's really enhanced our ability to work together. So we are hearing first this morning from Josh Kate, just to talk about some of those legal aspects, that we're all aware of that. We also have, and I want to be very thankful, because when we went into this with peacemaking, we did not have the support necessarily in Lansing from DHHS. We had it from our Supreme Court, and we had it from our State Court Administrator's Office, but for many of you who work for DHHS, it was not a full embrace, and so we had to just sort of set the tone. And I really want to thank you in Washtenaw County who are willing to walk this road with us. So we'll hear from Renee. I really appreciate that, about some of those policies and procedures. And as we know, sometimes we run into a little knocking heads when you as a worker say, well, that's policy, and we're saying, yeah, well, that's not the law. So that can have sometimes a difficult conversation, but it doesn't mean it is a conversation that needs to be had, and we need to work through for, again, who? There you go. You're listening. I love it. And you're feeling it. We also have then, very fortunate, from our State Court Administrator's Office, who has been here and behind us in peacemaking way back, Casey Ambender. And at noon, we have Justice Megan Kavanaugh coming and speaking about the importance of the work that we're doing here and why they do appreciate it up there. Finally, we'll have the chance to hear, which I think is a good way to end before your exercise, on the effect on the child. You know, Margaret and I are very fortunate in our lives. We have 5 grandchildren right now. And so it's like we're reliving that experience when they're young. And I have to tell you, as a grandparent, I see it a lot more than I did as a parent. I was just worried about getting the peanut butter sandwiches made for the next day and get them down to bed, and did they have a bath and up and falling asleep. I never stopped and really heard my children. I just didn't. So we need to hear that, again, all of us, to keep us centered. And then As I said, Linda will lead us in an exercise. There is no right answer. We even wanted to go further. Renee had all kinds of great ideas and questions. Said, we got 30 minutes, Renee. No, we're going to keep it simple. But it's really to begin thinking about a problem and understanding what we do with peacemaking and respecting different viewpoints so that collectively we can come with something that might work for our kids. So with that, thank you and welcome. And I think our first speaker is the man who looks like the folk singer from the 60s. Dr. K.
Well, yeah. He is not a folk singer.
Well, we'll still say it. We'll say it for the cameraman over there, too. Dr. K is a clinical assistant professor of law in the Child Advocacy Law Clinic that I was telling you about. He is also taught in the Child Welfare Appellate Clinic. He's litigated numerous child abuse and neglect cases in trial courts not only in this county, but other counties, in the Michigan Court of Appeals and the Michigan Supreme Court. What I love about Josh is that he has the background of both a lawyer but as a clinician. He understands the dynamics of the relationships and the connectedness of these kids and family and community. But after doing that for a few years, he decided to come to law school because of the overlap that he saw, like many of you are social workers. He joined the Michigan Protection and Advocacy Service as a skating fellow. What is a skating fellow? Is that a Finnish thing? No. Oh. Okay. And he represented parents with disabilities in child welfare cases and provided statewide consultation about child protection cases involving parents or children with disabilities, children that have even greater needs, the trauma that we have inflicted on them as adults. With that, I give you Dr. K, and thank you, Dr.
Great, thanks. Good morning, everybody. As Judge Connors said, I really come at this thinking as a lawyer, thinking about what are the legal requirements, but also trying to think about what is the effect we want to have on families. How do we go about our work of protecting children in the way that is minimally invasive, yet adequate for the child's safety, and minimally traumatizing, again, yet able to protect children. And so when we look at law, we really think about a set of tools, and we want to use those tools in the best way possible, the most effective way possible. We need to think about how we're going to use them. If I can have the first slide. So there are different sources of legal authority. There are statutes in the Michigan compiled laws. There are court rules, the Michigan court rules, and there's DHHS policy, which I know Renee is going to cover. I do have a couple slides about policies because I think about them from a litigator's perspective of what is the agency supposed to be doing, what does it see as its mandate. DHHS policy is not the law, but DHHS does have to follow its policies as a matter of law. So I would feel like if I covered the law of removal and didn't mention agency policy, I would be missing something rather important that we need to think about. All right, there are different times that removal is a possibility and different ways of going about it. And I really am covering this in a technical way. It's the law. It's what are these tools at our disposal. So there's a way to remove kids without a court order. And this can be done only by law enforcement. They're the only ones who can go into a house and remove a child without involving the court initially. Okay. And this is covered in Michigan compiled laws in the statute 712A.14a, but also in the court rules 3.963a. And the standard here, and you're going to see this standard repeated for other times that we might remove a child, is substantial or imminent risk of harm. And the statute says that immediate removal has to be necessary to protect the child's health and safety. So you have these words like imminent and immediate and necessary, really the legislature emphasizing those requirements that you need to do this when there's not even time to involve the court, even minimally. Okay. But if an officer does this, that officer must immediately inform the agency. Okay. And the officer or the agency then needs to inform the court, again, immediately. So you see that sort of urgency word immediately over and over and over again. This is really not to be used in any situation where there's time to even get an ex parte order, which is what I'm going to cover next. Okay, this is a situation where the emergency is utterly dire. Okay. So you can think of examples. So for example, an officer, set of officers, they raid a house, okay, and they find that there's a baby sitting in the middle of the floor, sucking his thumb, just sitting there. They can scoop up that baby and take that baby out of that house. They can do that, and then they can deal with letting the agency know, letting the court know, all of that. But they're in the middle of a police raid. It is an emergency. It's a dangerous situation. There's not time to sort of go, okay, I'm going to send my electronic request to the court. I'm going to wait. Maybe I'll call. Right? There's no time for that. It's just, got to go in, there's a child, take the child out. That's really what this is for. One second, almost. Now, when the officer or the agency does ask the court for an order, the criteria are going to be the same criteria as for an ex parte order of removal, which is what I'm going to cover next. So now it's good, perfect. All right. So an ex parte order, right? Ex parte just means one-sided, doesn't involve the respondent, doesn't involve an LGAL yet. It's just a request to the court for an order of removal. So it's for placement before a preliminary hearing can be held. Okay? So if the removal without a court order can be thought of where that's a removal where there's not even time to get an ex parte order before removing that child, this can be thought of as the child needs removal so quickly that there's not even time to wait for a prelim, say the next day. Can't wait that long, we've got to get the child out of the house. There's time to ask the court for an order, okay, but there's not time to wait for a prelim. And these involve the agency, generally, as you all know. We've all dealt with these. It also is covered in statute 712A.14b and in Court Rule 3.963b. And this is what the law says. This is also what your procedures say, the agency, right? So the agency submits a petition or an affidavit. It can be sent electronically, as you know, and a judge or a referee can issue this order. That response, the order, can be sent electronically. It does require written findings of fact. So the court needs to state why is it issuing this order at this time. One way to think about that, I think, is why does this order need to be sent? Why do we need to do this right now as opposed to waiting for a prelim? All right, can this wait for a prelim? If no, why not? Okay, so if it can't, why not? I think that's what the legislature really, and the court rules really want in the written findings of fact, is an answer or some consideration of that question, that if this can't wait for a prelim, why can't it wait for a prelim? Okay. This one has required elements, so it's a little, it's more of them than if an officer is going in and taking a child without a court order. All right, when the officer went in, it's basically this. substantial or imminent risk of harm, and immediate removal is necessary to protect the child's health and safety. That's very similar language to what the officers are operating under when they take a child without a court order. Okay? But there's more to it here. There are more elements. Okay? That circumstances warrant issuing an ex parte order. That's what the statute says. They don't really define that further. But doing some more digging, what that's about is that the circumstances warrant issuing an ex parte order instead of waiting for the prelim, or if this is later in the case, post-authorization, some sort of other post-authorization hearing, to issue an order of removal. Okay? Which is why, again, when you think about the written findings of fact, you're really talking about this. Why ex parte instead of waiting? What's the answer to that question? That's what the court should be able to articulate based on what it's being told by the people on the ground. And I realize, these are all very, these situations, they're complicated, they're fast moving, we're all doing a difficult job. And so the law is our set of tools for how to do that job. Okay, there's also a reasonable efforts requirement to prevent removal. That's not part of the law enforcement removal without a court order. They don't need to make reasonable efforts. But the agency does. The reasonable efforts made to prevent removal, that there's no other way to protect the child at this time. That removal is fundamentally necessary. Okay? There's nothing else we can do about this situation. And then staying in the home is contrary to the child's welfare. The contrary to the child's welfare phrase shows up again and again. There's a definition later in the slides of that from the court rules that we'll talk about. But that's sort of the fundamental finding. All right, so there's some DHHS policy. I'm sure this will get repeated. Regarding ex parte orders, if they're only after hours, that there's an immediate threat to the child's health or welfare. Again, this can't wait for a preliminary hearing. If we wait for a preliminary hearing, bad things are going to happen. We need to do it now. You still gotta talk with the parents and the children if they can articulate any of this information about potential placements. There's a reasonable efforts requirement. And then just, this was in the policy as well, that if law enforcement has already removed the child and they're handing the child over to DHHS, you can't receive that child without the ex parte order under DHHS policy. Okay. So, placement by court order in a preliminary hearing. One thing to think about here is based on some Court of Appeals authority, even if the child has already been removed, say with an ex parte order, removal needs to be actively reconsidered at the prelim. That it's still findings should be made. It's still there on the SCAO order form. The boxes need to be checked with reasons. Casey, you're smiling at the reference to SCAO. There you go, right? Tell us how to do lots of things. Okay. So, again, a 5-part test. Okay. Now, it used to be a 1-part test in Michigan. The rule was what is now the 3rd rule right here, just contrary to the welfare. That was not constitutionally sound. It's how we did it for a long time, but it wasn't what the federal courts said we should be doing, or any state should be doing, and so the 5-part test got put together. And when we get to the definition of contrary to the welfare, I'll explain why that's important. And now, because of the 5-part test, this actually it's still there, but it kind of gets subsumed, even though this is the main thing we talk about. So, what does the court need to find? That custody with the parents presents a substantial risk of harm to the child's life, physical health, or mental well-being. Okay, substantial risk of harm. Notice that the word imminent is no longer in there. We've gotten to a prelim. It wasn't a situation where the child needs to be taken without a court order. And that there's no way other than removal to safeguard the child. So that other thing, is there anything else we can do about this other than remove the child? I'm going to talk about a couple of those alternatives in a bit. And as I said, staying in the home is contrary to the child's welfare. Reasonable efforts were made to prevent or eliminate the need for removal consistent with the circumstances. Sometimes the circumstances are such that there's not a whole lot that can be done to prevent or eliminate that need. We get that. It just needs to be explained. That's all. Just needs to be explained. And I highlight all this because these are the things that we all need to be able to articulate in court. Right? We need to be able to walk through this and explain all of this so that the court can make a decision on a full set of facts needed for this finding. Okay, and then conditions of custody away from the parent are adequate to safeguard the child's health and welfare. So there's some consideration of what's the placement like, right? So is it licensed foster care? Is it with a relative? What do we know about that relative? What? So that is sort of a major addition, actually, when they created the 5-part test, which is just a few years old. That's a major consideration is, all right, if we're taking the child, where are we putting the child, and is that okay? All right? And I know that's something DHHS, of course, think about where are we putting the child. That's considered. But it also is, it's part of the law. It needs to be talked about in court. Okay. So some additional procedural thoughts regarding placement pursuant to a preliminary hearing. The court must receive evidence unless waived to establish that the criteria, the 5-part test, to establish that the criteria are present. This is very similar language to the petition must be read unless the reading is waived. Probable cause finding, which can be waived. Right? So this is actually an affirmative requirement for a discussion in court about removal. Evidence needs to be received unless that is waived. Who holds the waiver? That would be the respondent. Just like they hold the waiver regarding reading, they hold the waiver regarding probable cause. So we've got to be actively receiving this evidence to establish that the criteria are present. Unless that's waived, this is pursuant to a court rule, 3.965C1. 3.965 is the preliminary hearing rule for those who are not as familiar with court rules. Okay? And when that evidence is received, again, unless it's waived, the respondent needs to be given an opportunity to cross-examine witnesses, subpoena witnesses, and offer proofs, generally, to counter that evidence. Okay? So this is a requirement that there needs to be, this is a litigation requirement. There needs to be litigation around removal. Now, one of the things I've seen, and to some effect, Steve and I were talking about this earlier, often there's a discussion, I've been finding more and more at trial, about what were the circumstances of removal, should this case really have gone like this, which I think is effective in terms of, say, how it plays to a jury. They think about that. Should this even be a case? Should this have started? Should the kid have been removed? It's not, strictly speaking, nearly so relevant at trial as a legal matter. The removal happened, often it's months ago at that point. This means that we really need to be litigating this up front. That it should be an active question. Evidence needs to be presented. Okay. And it requires, removal requires a statement of the contrary to the welfare findings. Those findings need to include reasons behind them, some factual findings. Those findings need to be written down or capable of being transcribed. There's the court rule that requires this. And I added this isn't in your handout. I just, total oversight, I was thinking about it and then I realized I never wrote that in, so I wrote it in this morning. But what does contrary to the welfare actually mean? So it includes, but is not limited to situations in which the child's life, physical health, or mental well-being is unreasonably placed at risk. If we go back right there, so here you go, that's actually criteria 1. And just because of how this got written after this, it became criteria 1 and 3, which is why 3 kind of got subsumed by all this. We can go back to, and nevertheless, contrary to the welfare findings need to be made. And the reason that that was insufficient before, constitutionally, is because of this language. Includes, but is not limited to. That was too much room there for the Constitution, because parents have a fundamental constitutional right to the care, custody of their child, unless the state has a really good reason to infringe that right. Okay? And saying includes but is not limited to just left the universe wide open for why we could take a child from a parent. So the 5-part test got written by the legislature after an incredible amount of educating legislators, term after term after term. But it finally got written. So now we're constitutionally sound, but contrary to the welfare, this is what it means. It's still part of our law. The findings need to be made. Okay. Renee's going to talk more about reasonable efforts. Are you planning to a little bit? All right, I'll just cover this real quick. I've thrown it in there because, again, I can't write about the law of removal without considering DHHS policy. I think they're part and parcel. These are things that can be discussed in court. These are things that a CPS specialist could be questioned about on the stand. These are all legitimate areas of inquiry, so I've got to include them. So, what efforts were made, or why wasn't it possible to provide reasonable efforts? These are questions that are needed. What's the likely harm if separated? If that's already been done, what's likely harm if the child's returned to the parent? This, and I'll talk a little more about this, that CPS should consider requesting the court to order the alleged perpetrator out of the home. That's a solution, right? Because kids, and you'll hear about this from Kate Rosenblum, and we all know something about this, it's inherently traumatic to be removed from your home. That's true, no matter how bad the house is, actually. No matter how bad it is to live there, that's the child's norm, and changing that norm suddenly is inherently traumatic. It may be a necessary trauma, no doubt, but it needs to be thought about. And so if we can minimize that in some other way, by being a little bit, by taking a left turn instead of a right turn, and ordering, say, the perpetrator out of the house, that's great. And we know that reasonable efforts are not required by policy under some circumstances. In those circumstances, though, the court can still require them. So the court can do it by order. All right, so there's some law about removing an abuser from the home. Of course there is. Okay, so it requires all of these elements so that the petition alleges that that person is the abuser. Makes sense. That there's probable cause to believe that that's indeed the case. Probable cause, again, it being a pretty low standard, legally speaking, okay, an easily crossed bar. And the court finds on the record that the person's presence in the home presents a substantial risk of harm to the child or the children. Okay? Those three things together, and the court can order that the abuser leave the home and not come back until The court decides. The court needs to also find, in cases like this, that the conditions of custody in the home are adequate to safeguard the child, so that even if the abuser is removed, still got to think about, okay, well, what's going on still in the house? Who's left? What are the dangers? What are the conditions? Are they okay to safeguard? Are they good enough to safeguard the child's safety? Then we can do this, right? If not, then no, this isn't the approach to take. Okay, so where a child, I tell my students in the clinic that there are a couple of questions that are always live questions in child protection, no matter what hearing you're in. Questions about parenting time and questions about placement. Doesn't matter what hearing you're in, those are live questions. They can always be raised. The court should always entertain them. My experience is that this court certainly always entertains them if there are things to talk about on that score. But there are other ways, there are other times that, because placement is always a question, there are other times that we can talk about removal as well. It's not just putting the child back in the home, it's not just where is the child, it's also does the child need to come out of the home at this point. So one is by motion under the court rules. You can make a motion to remove a child, 3.966A, then it circles back and says, you know those 5 criteria in 3.965, the preliminary hearing rule, gotta follow those. So it's just you flip the page in the book to that rule and you follow that. Okay. Pre-adjudication, you can amend a petition where maybe you weren't seeking removal before, now you're seeking removal. That would trigger it, okay? Again, follow the criteria. Post-adjudication, all right, a supplemental petition can be filed. We think of those usually in terms of termination of parental rights, but this is a different kind of supplemental petition to remove a child from the home. This is the court rule that says you can do this. And again, you circle back to the 3.965 criteria and that 5-part test. And then you can also have emergency removals. Even after the petition's been authorized, you can have emergency removals, and you've got to follow the ex parte order rules. Okay, and then you got to have a hearing after that. So it's like an ex parte removal, but later in the case than when we're used to seeing it. All right, again, got to think about, is this so bad that we cannot wait for a hearing? That we can't do it by motion, get in? The court is very accommodating about scheduling motion hearings very quickly if need be. So got to think about, is that still not fast enough? In that case, it can be ex parte. There is a place for ex parte orders. There is a place to wait for, and there's a time to wait for a prelim. And that's the last slide. Yeah, so I've got time for questions. There's not a ton of law on removal, so questions about the law of removal. Rick?
I just have a question about the language of mental well-being.
Yeah.
It seems that next to the other 2 categories, that I see well-being as being in a very different camp than safety and threat to life.
Okay. So
could you clarify what that, does that open it up more?
I think what it is a recognition. So the question was about the language of mental well-being, and when you think about like risks of serious harm to the child, how does that fit in? I think it's a recognition that psychological harms can be very severe, and that children need to be protected from those circumstances, sometimes imminently. That once they come to the attention of the agency, we can't let that be going on. And that I think there are a lot of times that the harms are actually all of the above, that they're together, right? So if a child's being physically abused, that is psychologically deeply harmful, right? So what we're trying to do is protect children holistically, thinking of the whole child, thinking of their well-being broadly. Nevertheless, the risks that we're talking about, they need to be serious and substantial. There needs to be no other way to deal with those risks right now. Again, could you get the abuser out of the home? Could you, can you put services into the home in some way? What can we do about this short of removal? It needs to be an active question, regardless. But I think mental well-being, mental harms, that's really what I mean. We're talking about mental harms, physical harms. Yeah, Kim.
So I just want to make 2 points. One is that this whole issue of mental harm is, I think, one of opinion. And by that I mean children are in all kinds of dysfunctional homes and are being harmed mentally. But I don't find the sensitivity for the understanding about how removal on top of that is in some ways even more harmful than leaving the child in the home. And I think that I can appreciate the fact that that's a pretty heavy call for most DHHS workers, and probably a pretty heavy thing to, I think it's easier to say, get them out of there because we know that the dysfunction exists.
Yeah.
Okay? Instead of understanding that you're piling on top of this kid's experience. So that's just one thing I wanted to say.
Right, I think that what you're pointing to is that number 2 in the criteria for removal, that there's no other way to deal with this. Part of what you're pointing to is that we really need to take that very seriously. That we've got to determine that there's not some other way to do this. We also have to be thinking about the urgency of the situation.
Well, let me just say just one more thing.
Yeah, go ahead.
I think that's too clinical.
Okay.
And the reason I'm saying that to you.
That would be me.
Yeah.
Yeah.
It's okay.
Clinical
It's all
professor
us.
of law,
It's all of us. It's all of us, because those
Yeah.
5-point
That
things
is my
sound
title.
so rational, and they sound so neat.
Sure,
And
yeah.
we can all relate to
Statutes
them as
usually do.
intellectual beings.
Yeah, yeah,
right?
of course.
But the other thing is that the services that would be put in, i.e. a Families First or removal prevention, these services are pretty certain. I would not call these in-depth services. And I don't think the agency has anything else, and I'm not being disparaging, I'm just saying this is the reality that we're all living in this system together. And so some people who have whatever is going on in their family need far more hand-holding. And yet it's, I think, the system looks to remove those type of kids in those situations because we don't really have any hand-holding services on that level. And I hope I'm explaining myself well. To prevent removal. Okay. My sense of the direction that people want to go is to try to reduce the number of removals up front. But I see that as complicated because I feel that the services, the community of clients that I deal with today are not the community of clients that I dealt with 20 years ago.
Yeah.
The depth of the need and the problems in the home are bigger.
I think that's right.
Yeah,
I mean, we've been seeing that too.
And so it's
Yeah.
easy to go into that situation and remove children. But I can tell you on the flip side, kids are no more better in a better situation in removal in some instances. And so what are we really doing? Now we can articulate and intellectualize those factors 1, 2, 3, 4, and 5 and feel good that we've done something. But in reality, and I've had cases where we just sending the kids back home because we can't do nothing. Done a little something, but we aren't getting anywhere. Kids are being removed multiple times. That certainly isn't good for the kid. And as an LGAL, I can tell you, I get to the point where I'm like, well, we in the system aren't doing any better than what these kids were living in. And so, so I just want to put that out there because these 5-point, 2-point, 3-point factors in the law, I don't really think, as a practitioner, and I think this is true in the court, and I know it's true in workers that I work with, these issues are, they're, I don't know, they're heavy, man.
Right, okay, let me just say a couple things about that.
Yeah.
One is, right, I don't think the law alone is adequate. It is kind of highly intellectualized, it's kind of highly distilled. Law tends to, like, just law itself tends to prefer to simplify problems that sometimes can't be simplified. I don't think the law is per se adequate as a way, as sort of a case-working way to think of these situations. I think families have needs that are really complex. But
No,
these
but it
are,
is important how the
right.
individuals that carry out the law, the courts, the
Yes,
DHHS,
yes.
the caseworkers, the lawyers, how we interpret those words.
Right. Yes, and there's very little case law. Something I meant to mention. So there's very little case law on removal. So the Court of Appeals and the Michigan Supreme Court have not talked a heck of a lot about removals. So,
It's
which
an area
would,
that
from a...
the defense bar has not focused a lot on, and I admit that.
Correct. And it would, and there would be more of it if it got litigated more actively. And so what I'm talking about is a set of legal tools for doing just that. Is it, do I think of, you know, is this how I would think of it if I was operating as a psychologist? No, probably not. It wouldn't be enough. But whatever I do with that, say as a psychologist, if I have to give evidence in court, the evidence is going to have to conform to these requirements for the court to make its finding.
I understand.
Yeah.
I just felt that that needed to be said.
Mm-hmm. Yeah. Other questions? I think there's a couple more minutes. Mm-hmm.
I have something, I don't know if you have any thoughts on this, or I just wanted to bring it up. An additional option, possibly, as far as in-home wards, to provide an additional layer of monitoring by the court and to be able to order services as an option away from removal.
Right, yeah, so we often call them like in-home jurisdiction or in-home wards. Yeah, I've seen that done in you know, some cases where the situation was such that petition did need to go to the court needs to be involved. You need that level of sort of monitoring and, you know, an additional layer of authority, basically, to get the job done. But that there wasn't necessarily a reason to remove the child, that there's a reason to intervene with this family in a strong way, that there's a reason to watch the situation really carefully, make sure it comes back before an impartial jurist to make decisions, to make sure everybody's doing what they're supposed to do. But not, that is another option. Absolutely, you can do a petition and not ask for removal. That's right. That's right. Any other questions?
I have a question.
Sure. Apparently it's a funny one. Yeah.
No, it's not funny.
Okay.
So, about, I'm gonna say 20 years ago, like when your kids were removed, I guess what I'm saying is we have a lot of families that have substance abuse issues, and how can we get it where the kids, instead of being removed and put in foster care, could be put with the parents and they go to an inpatient program, like a program that will accept moms with children. That way they're able to work on everything. And I mean, I've seen it happen, and what was put in place was that if the mom chose to leave the treatment center, there was an order put in place where she couldn't take the kids.
Right.
You know, because I think that there's a lot of services that, I think we have parents that are kids in mind, because you know once you pick up and start using, you start growing. So you got these kids having kids.
Right.
And I don't know, I'm just...
That's a really, so There are relatively few of those programs. I have worked on cases where workers have looked at the possibilities, maybe couldn't get someone in, or maybe there were some other concerns as well, that even the level of supervision at that place wasn't actually adequate potentially to keep the child safe. But it has been actively considered in a few of my cases. I think if we had more of those, I mean, we have a service deficit in this state, in many states. It's really hard to find services. Everybody's out there seeking, trying to figure out what to do for families. It's a hard job. And one of the reasons it's hard is there aren't a ton of services. And there aren't a lot of those facilities, actually, but there are some.
Yes, they are.
Dr. K?
Yes?
I just wanted to share some hope. That's a really great point. And I wanted to share that there's historical federal legislation that was passed 2 years ago called the Families First Prevention Services Act. And DHHS, our state, has committed to the feds to start implementing the provisions of those acts in 2020. And one of the mandates from the feds that will be tied to 4E funding, we all know when we hear 4E funding, then we actually do it, right?
Yep.
Is that they must have a significant amount of programs where children can be placed with their parents in substance abuse facilities. So keep hope alive. I swear it's coming at some point.
I hope so. It's also been a mandate in the state of Michigan that every county is supposed to have access to multidisciplinary trauma assessment and treatment teams, and that's in a statute. And it just wasn't done by the legislature. So I want to share your optimism. And I'm trying hard too, but I'm having a little trouble. Yeah. Just to give a counterpoint, like, there are a lot of legal requirements that don't necessarily get fulfilled. I hope it is because it's tied to funding, and that always helps. All right, thanks very much for your attention this morning. Appreciate it.